Hello everyone. Today I am going to discuss with you a very important topic, that is the Medical Termination of Pregnancy Act 1971 and also the Medical Termination of Pregnancy Amendment Act 2021. First of all, let me discuss with you the objective and the purpose for which this particular act was enacted by the government of India. Obviously, we all know that before 1971, there were, 5 million terminations in India itself, termination of pregnancy, and out of this 5 million, almost 3 million were illegal terminations, right? So approximately 1/7 of women who become pregnant in India every year, they resort to unsafe termination methods at the hands of, we can say, inexperienced persons or paramedical personnel like nurses, midwives, and they lack the necessary experience, and because of this it resulted, in risk of high morbidity and mortality amongst pregnant women and their children, right? Basically in 1960s, the period of 1960s, we saw that several countries started enacting laws that legalize medical termination of pregnancy, and the Medical Termination of Pregnancy Act 1971, it is also modeled on the Abortion Act of 1967, which was passed in the United Kingdom. Okay. And in order to lay down the laws regarding medical termination of pregnancy, the government of India also set up a committee. Okay, the name of the committee was Shah Committee, and it was under the leadership of Mr. Shantilal Shah, right? And this was also done, at that point of time when countries were attempting to, liberalize termination laws. Okay, and there were many countries who actually legalized medical termination of pregnancy. Now, this Shah committee, when it submitted its report, it observed that, whatever may be the moral and ethical feelings that are proposed by the society as a whole, when it comes to the question of induced abortion, it is a fact that a number of mothers are prepared to risk their lives because by undergoing an illegal abortion, right, rather than carrying that particular child to term. So the committee submitted a very comprehensive report, and it suggested various situations which actually justified the legal termination of pregnancy. Why? Because it will, if it is allowed, it will not only save the life of the pregnant women, but it will also avoid any kind of mental, injury, mental health should not be abused, because if this will be allowed, then mental health will be distorted, right? It will also give rise to injury to a physical health of a woman, right? So obviously before this legislation was enacted, a lot of debate was going on as to whether this law should come up, and whether to combat the problem of rising population and to ensure that women have safe access and safe methods of termination of pregnancy, right? So they should be given reproductive rights, enhanced reproductive rights. All right. When we talk about fundamental rights, then of course, when we talk about Article 21, which talks about personal liberty, obviously reproductive choices are included in reproductive personal liberty, isn't it? Because a woman's right to make reproductive choices is also a dimension of personal liberty under Article 21 of the Constitution. And this has time to time emphasized by the Supreme Court of India. Right? For example, there's a case law, Suchita Srivastava versus Chandigarh administration. Okay, in this case, the Supreme Court emphasized and it held that, it is very important to recognize that reproductive choices can be exercised, okay, to procreate and also to abstain from procreating, okay, because A woman's right to privacy, dignity, bodily integrity, it should be respected, right? And that means there should not be any kind of restriction on the exercise of reproductive choices, okay, such as women's right to refuse participation in sexual activity, or insistence on use of contraceptive methods, right? So in this case of Suchita Srivastava versus Chandigarh administration, the Supreme Court laid down the best interest test, right, and substituted judgment test. The best interest test, it requires that the courts should ascertain the course of action which would serve the best interest of the person who is in question, right? And this decision should be guided by the interest of the victim alone and not of the guardians or of the society, okay? And the application of the substituted judgment test, it requires the court to step into the shoes of a person who is considered to be mentally incapable and attempt to make the decision which the said person would have made if he was not incapable. That means if that person was competent to do so. Okay. So in this case of Suchita Srivastava, the court also made a difference between mentally ill and those who suffer from, mild mental retardation. Okay. So the Medical Termination of Pregnancy Act 1971, after this judgment, was also amended accordingly. Okay. So in 2002 it was amended, and the latest amendment that we have is of the year 2021, that is the Medical Termination of Pregnancy Amendment Act 2021. So basically, we can say that this is the overall objective of the Medical Termination of Pregnancy Act 1971. All right, because when we talk about Constitution, fundamental rights, Article 21, a woman cannot be deprived of her fundamental rights which have been provided and guaranteed by the Constitution of India. So this is the main objective of the Medical Termination of Pregnancy Act 1971. In the next video, we will discuss section wise, like section 2 clause A, section 2 double A, right, section 2 clause E, which has been inserted by the Medical Termination of Pregnancy Amendment Act 2021, and the main sections that we need to cover are sections 3, 4, 5 and 6. So thank you so much. Keep watching more videos. Thank you.